Love them or hate them, President Trump's tariffs have not only been a talking point, but have had an impact on most Americans. The question before the Supreme Court in this case is whether or not the president has the power to create these tariffs in the first place. So we'll look at that next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your action generation be free. Glad you could join me today. Tariffs, taxes. People hate paying taxes, but they're a necessary evil. The question is, who gets to lay and collect those taxes? That's at the corner of this case. If you'd like to follow along, you can find the article at the website constitutionstudy.com. You'll also find links to all my sources on that page. I'll talk more about the websites and how you can support the work that we're doing here, but for now, let's talk about this case of tariffs. Before we dive into the oral arguments about these tariffs, I think it's important we define what a tariff is. From the Free Legal Dictionary, a tariff is the list of items upon which a duty is imposed when they are imported into the United States, together with the rates at which such articles are taxed. The term tariff is also used in reference to the actual custom or duty payable on such items. So a tariff is both a list of items that will be subject to a duty and the duty to be paid. This is important because the Trump administration is basing its power to impose both parts of the tariff on the International Emergency Economic Powers Act, or IEEPA, which states, in general, at the times and to the extent specified in Section 1701 of this title, the President may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, investigate, regulate, or prohibit any transaction in foreign exchange, transfers of credit, or payments between, by, through, or to any banking institution to the extent that such transfers or payments involve an interest of any foreign country or a national thereof, the importing or exporting of currency or securities by any person or with respect to any property subject to the jurisdiction of the United States. Now, the major question presented to the court is, does the term regulate include the power to tax? The case in question is Learning Resources, Inc. versus Trump. An oral argument started with John SAUER, Solicitor General for the United States.
Mr. Chief Justice, and may it please the Court. On April 2nd, President Trump determined that our exploding trade deficits had brought us to the brink of an economic and national security catastrophe. He further pronounced that the traffic of fentanyl and other opioids into our country has created a public health crisis, taking hundreds of thousands of American lives.
President Trump determined that the nation's trade deficit had brought us to the brink of collapse. He also decided that the trafficking in fentanyl has created a public health crisis. This is the justification for his enacting tariffs under IEEPA, which states, any authority granted to the President by Section 1702 of this title may be exercised to deal with any unusual and extraordinary threat which has its source in whole or substantially part outside the United States to the national security, foreign policy, or economy of the United States if the President declares a national emergency with respect to such threat. However, since the trade deficits have existed for decades, what has made them suddenly unusual and extraordinary? After all, for there to be an emergency, there must be sudden, unforeseen happening which requires action to correct or to protect lives and or property. And to invoke IEEPA, the threat must be substantially or in whole from outside the United States. Yet foreign commerce, by definition, must include participants within the United States.
President Trump has declared that these emergencies are country-killing and not sustainable, that they threaten the bedrock of our national and economic security, and that fixing them will make America a strong, financially viable, and respected country again.
President Trump declares these emergencies are country-killing and not sustainable, but not that they are an unusual or extraordinary, which is necessary to invoke IEEPA. Neither are they sudden or unforeseen to constitute an emergency.
Due to IEEPA tariffs, President Trump has negotiated agreements worth trillions of dollars with major trading partners, including most recently China. Unwinding those agreements, he warns, would expose us to ruthless trade retaliation by far more aggressive countries and drive America from strength to failure with ruinous economic and national security consequences.
Just because a president has negotiated agreements doesn't mean he had the legal authority to impose the tariffs he used to initiate the negotiations. Furthermore, since Congress is vested with the power to regulate commerce with foreign nations, these actions by the president are unconstitutional. And since none of the agreements included a treaty, they have no legal force within the United States.
In Dames and Moore against Regan, this court held that IEEPA's sweeping and unqualified language grants the president's actions the strongest presumption of validity and the widest latitude of judicial interpretation. Yet plaintiffs argue that tariffs, IEEPA's least blunt and most nimble tool, are virtually the only tool that Congress did not grant the president to deal with foreign emergencies. That is wrong. The phrase regulated importation plainly embraces tariffs, which are among the most traditional and direct methods of regulating importation. And plaintiffs concede that IEEPA authorizes quotas and other tariff equivalents.
Except nowhere else that I'm aware of is the power to regulate understood to include the power to tax, but I'll talk more about that later.
The major questions doctrine does not apply here. IEEPA confers major powers to address major problems on the president, who is perhaps the most major actor in the realm of foreign affairs. And the non-delegation doctrine casts no doubt on IEEPA because Congress may assign the president broad authority regarding the conduct of foreign affairs, or he enjoys his own inherent Article II powers. I welcome the court's questions.
Enter the question of the major questions doctrine, which the Cornell Legal Information Institute defines as: the major questions doctrine is a structural principle of administrative law that restricts federal agencies from interpreting statutes and assessing broad policymaking powers of great economic or political significance without a clear congressional mandate. So the second question the court has to answer is whether or not the president imposing a tariff is a broad policymaking power or not. Next, we'll hear arguments from NEAL KATYAL on behalf of the private parties involved.
Thank you, Mr. Chief Justice, and may it please the Court. Tariffs are taxes. They take dollars from Americans' pockets and deposit them in the U.S. Treasury. Our founders gave that taxing power to Congress alone. Yet here the President bypassed Congress and imposed one of the largest tax increases in our lifetimes.
Mr. KATYAL is correct. Tariffs include duties which are a form of taxation, and specifically delegated to Congress in Article 1, Section 8, Clause 1. Congress shall have the power to lay and collect taxes, duties, imposts, and excises. So does IEEPA give the president the power to impose duties on imports, which he did with these tariffs?
Many doctrines explain why this is illegal, like the presumption that Congress speaks clearly when it imposes taxes and duties, and the major questions doctrine. But it comes down to common sense. It's simply implausible that in enacting IEEPA, Congress handed the president the power to overhaul the entire tariff system and the American economy in the process, allowing him to set and reset tariffs on any and every product from any and every country at any and all times.
I think Mr. KATYAL is being a bit hyperbolic to claim that the president is attempting to overhaul the entire tariff system and the American economy. Still, I think there is a point when it comes to Congress speaking clearly when it imposes taxes and duties.
IEEPA is a sanction statute. It's not a tax statute where Congress gave away the store. Congress knows exactly how to delegate its tariff powers every time for 238 years. It's done so explicitly, always with real limits. IEEPA looks nothing like those laws. It uses regulate, which Congress has used hundreds of times, never once to include tariffs, and it lacks the limits of every other tariff statute. And that is why, even though presidents have used IEEPA to impose economic sanctions thousands of times, no president in IEEPA's 50-year lifetime has ever tried to impose tariffs. And the president bypassed statutes that do address tariffs, like Section 122 for large and serious trade deficits, but that imposes a clear guardrail, 15% cap, 150-day limit.
Again, the point is raised. Does the power to regulate include the power to tax? And what about Mr. KATYAL's claims that Donald Trump bypassed statutes that include the power to issue tariffs? Were they left behind because they're limitations? And do their limitations add the power to tax onto the power to regulate?
This is Youngstown at its lowest ebb. If the government wins, another president could declare a climate emergency and impose huge tariffs without fines or without floors or ceilings, as Justice Gorsuch said. My friend's answer, this administration would declare it a hoax. The next president may not quite say that. This is an open-ended power to junk the tariff laws and is certainly not conveyed by the word regulate. I welcome the court's question.
I almost think Mr. KATYAL is being a bit hyperbolic again, until I remembered President Obama and Biden and their attempts to enforce carbon and other taxes in support of their hoax, man-made global warming schemes. Last up is Benjamin Gutman on behalf of the states who joined the suit. Now, during his argument, Mr. Gutman focused on questions about licensing and licensing fees.
Mr. Chief Justice, and may it please the Court, I'd like to begin by picking up with the exchanges with Justice Barrett and Justice Gorsuch about licenses and license fees, because I think we ended on the right note, but I just wanted to make sure that at least my client's position is clear on this. Licenses are different from license fees. And I am not aware of any history in the 5 decades that IEPA has been in force of any fees charged for the licenses under this statute. This is a statute that licenses can be used, for example, the president might ban certain transactions with a foreign country, but then grant licenses to do them for humanitarian reasons. But as far as I'm aware, there's never been a fee charged for that. And I do welcome the Court's questions.
I'm not sure why Mr. Gutman focused on this one topic, but I think we'll see the discussion expand under questioning. As I mentioned, one of the points used by the state and private parties is that President Trump violated the major questions doctrine. Solicitor General SAUER defends the president's position.
Would you spend a few minutes on why exactly the major question doctrine doesn't apply to the president in this case?
Yes, Justice Thomas, and I'd maybe make 2 or 3 points on that front. First of all, though the major questions doctrine may apply to the president in other contexts, specifically in the foreign affairs context where he has his own inherent Article II authority, it's a particularly poor fit to apply the major questions doctrine, and that's for at least 2 reasons. That's one reason. One reason, just as a matter of common sense interpretation, you would expect Congress to grant major powers to the president who has his own broad range of major authority, inherent Article II authority in this context.
Except Article 2 of the Constitution does not delegate to the president any real foreign affairs powers. He shall have the power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present occurred, and he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors. He shall receive ambassadors and other public ministers. But nowhere in the Constitution is the president given the power to conduct foreign affairs outside of these 3 powers. Justice Kagan seemed to catch on to this idea.
General there, and I know that you have a second question, and I want to let you get to that. But just on that first reason, it seemed to depend a lot on the president's inherent Article II powers. And I'm wondering what exactly, which powers you're speaking of there, because tariffs, one would naturally think, is are the power to impose taxes, the power to regulate foreign commerce. These are not things that are thought of as Article II powers. They are quintessential Article I powers. So what kind of Article II powers are you relying on when you gave the answer about major questions to Justice Thomas?
I would refer to what the court said, for example, in Egan, Department of Navy against Egan. That's a generally accepted view that the president has broad authority in the foreign affairs realm. Now, there's been debates about exactly how far it goes and how to draw the boundary between the president and Congress. But Egan, Garamendi, other cases, Curtis Wright, the court has recognized the president has broad inherent authority to address foreign situations, foreign affairs, foreign policy, including foreign arising emergencies.
So the president does not have any Article II powers to conduct foreign affairs, but powers made up by courts. Interesting. Next, let's look at the non-delegation doctrine. To understand the non-delegation doctrine, we need to start with a definition. The non-delegation doctrine is a constitutional principle that Congress cannot delegate its legislative powers to another branch of government or to private entities. The doctrine primarily arises in administrative law and constitutional law, addressing the limits of Congress's ability to authorize agencies to make rules with the force of law. Now keep this in mind, as this will be essential to understanding the questioning we are about to delve into. Justice Gorsuch had a somewhat heated discussion with Solicitor General SAUER about the non-delegation doctrine.
It's the gist of it, as I understand it, why we should disregard both major questions and non-delegation. So could Congress delegate to the President the power to regulate commerce with foreign nations as he sees fit, to lay and collect duties as he sees fit?
We don't assert that here. That would be a much harder case now. In 1790,
isn't that the logic of your view, though?
I don't think so, because we're dealing with a statute that was a carefully crafted compromise. It does have all the limitations that I just talked about.
Interesting position for Mr. Sauer. If this statute is as carefully crafted as he claimed, then we have to assume that since Congress didn't include the power to establish duties, they didn't intend to delegate that power to the United States. Then Justice Gorsuch got into the question of foreign affairs.
I want to explain to me how you draw the line, because you say we shouldn't be concerned because this is foreign affairs and the President has inherent authority, and so delegation off the books, more or less. And if that's true, what would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war, to the President?
We don't contend that he could do that.
Why not?
Well, because we're dealing with a statute, again, that has a whole series
I'm not
of
asking about the
limitations.
statute. General, I'm not asking about the statute. I'm asking for your theory of the Constitution and why the major questions of non-delegation, what bite it would have in that case.
Yes, I would say by then you would move from the area where there's enormous deference to the President, actually both the political branches, where here there's inherent authority, and piled on top of that there's a broad delegation.
You're saying there's inherent authority in foreign affairs, all foreign affairs. So regulate commerce, duties and tariffs and war. It's inherent authority all the way down, you say. Fine. Congress decides tomorrow, well, we're tired of this legislating business. We're just going to hand it all off to the President. What would stop Congress from doing that?
That would be different than a situation where there are metes and bounds, so to speak. It would be a wholesale application.
You say
While it may be a different statute, the underlying question Justice Gorsuch seems to be asking is, how far can Congress go in delegating their powers to the President? And I don't think Solicitor General Sauer had a very good answer. Now, in questioning Mr. KATYAL, I think Justice Thomas exposed another very serious question.
Let's go back to your non-delegation point. It would seem that if the tariff power cannot be delegated, your argument on non-delegation would also have to apply to embargoes and to quotas.
No, Your Honor, because I think tariffs, because they're uniquely revenue-raising, impose special, unique concerns that go back to our founding. And so I don't think that they apply to embargoes.
If Congress can delegate its power to regulate foreign commerce, why not its power to tax? Mr. KATYAL seems to think that Clause 1 of Article 1, Section 8 has some special power not applied to Clause 3. Now we get to the heart of the argument. Does the power to regulate include the power to tax?
I want to make a very important distinction here. We don't contend that what's being exercised here is the power to tax. It's the power to regulate foreign commerce. These are regulatory tariffs. They are not revenue-raising tariffs. The fact that they raise revenue is only incidental. The tariffs would be most effective, so to speak, if no person ever paid them, if they achieve their goals.
Remember, when we define the word tariff, a tariff includes both the list of items and the duties that are to be imposed on them. A duty is a tax. With respect to the laws relating to customs duties, a tax owed to a government for the import or export of goods. Now, there is no such thing as a non-revenue-raising duty. So there's no such thing as a non-revenue-raising tariff. So General Sauer's statement is just plain nonsense. Justice Sotomayor made this exact point.
I just don't understand this argument. It's not an article. It's a congressional power, not a presidential power to tax. And you want to say tariffs are not taxes, but that's exactly what they are. They're generating money from American citizens, revenue. And you say it's incidental to the regulatory purpose. But I don't see how a quota is equivalent to revenue raising. A quota sets a limit to what you can import in, but it doesn't generate revenue.
Then Justice Barrett asked the very question that is at the cornerstone of this case.
Sauer, can I just ask you a question? Can you point to any other place in the code or any other time in history where that phrase, together, regulate importation, has been used to confer tariff-imposing authority?
Well, as to regulate importation, That was held in TWIA. So obviously, and that's
Okay. So an intermediate appellate court held it in TWIA, but you just told Justice Kavanaugh that wasn't your lead argument, that your lead argument was this long history of the phrase regulate importation being understood to include tariff authority. So my question is, has there ever been another instance in which a statute has used that language to confer the power?
Well,
putting aside Yoshida.
I mean, obviously, other statutory example is just imports. The cases we rely on are cases where, for example, in Gibbons, it's Ogden and Justice Story's
But that just shows the word can be used that way. None of those cases talked about it as conferring tariff authority. I understood you to be citing McGoldrick and Gibbons in those cases just to show that it's possible to say that regulating commerce includes the power to tariff.
So apparently, no law, no statute has ever implied that the power to regulate included the power to tariff or tax. Even General SAUER's attempt to answer shows the weakness of this argument, since the only thing he can point to are court cases that, according to Justice Barrett, do not show that regulating commerce includes the power to tax.
Because the natural understanding of regulate, even though, in fact, we can regulate through taxes, but when the code uses regulate, we don't typically understand it to refer to duties or taxes or tariffs or anything of the kind.
If the power to regulate includes the power to create duties, why is the power delegated to Congress to lay and collect duties separate from the power to regulate foreign commerce? Since the Constitution separates those powers, placing the power to collect duties in Clause 1 and the power to regulate foreign commerce in Clause 3 of Article 1, Section 8.
So yes, sure, the tariffs are a tax, and that's a core power of Congress, but they're a foreign-facing tax, right? And that foreign affairs is a core power of the executive. And I don't think you can dismiss the consequences. I mean, we didn't stay this case, and one thing is quite clear is that the foreign-facing tariffs have in several situations.
Right, and we are.
I'm sorry. Were quite effective in achieving particular objectives. So I don't think you can just separate it when you say, well, this is a tax to Congress's power. It implicates very directly the president's foreign affairs power.
Yeah. Mr. Chief Justice, we don't disagree with a large part of that. We think instead of thinking about foreign versus domestic, the better way of thinking about it is Article 1 versus Article 2. And as my friend finally conceded to Justice Gorsuch, there is no Article 2 power here, at least when we're talking about peacetime.
Except, as both Justice Kagan and I have already pointed out, there is no foreign affairs powers delegated to the president, not in Article 2, nor in any other clause of the Constitution. The fact that Chief Justice Roberts thinks they are effective doesn't make them legal. Well, Chief Justice Roberts doesn't seem to get this. Justice Sotomayor does.
Well, I think what we're forgetting here is a very fundamental point, which is the Constitution is structured so that if I'm going to be asked to pay for something as a citizen, that it's through a bill that is generated through Congress and the president has the power to veto it or not. But I'm not going to be taxed unless both houses, the executive and the legislature, have made that choice, correct?
That's exactly right.
So there is something, it's not just the taxing power, qua taxing power. The question is, do we permit the president to use the taxing power to affect his personal choices of what is good policy for me to pay for?
That's exactly right. The question is who decides.
Taxes are imposed by the only branch of government elected by the people to represent the people and the states. Congress, not the president. In fact, the framers of the Constitution went a step further, where they stated all bills for raising revenue shall originate in the House of Representatives. Now, after all that, what can we conclude from these arguments? First, tariffs, by definition, include duties, which are taxes. Second, the power to lay and collect taxes is vested in Congress, not the presidency. Third, when Congress passed a law allowing the president, under certain circumstances, to regulate any transaction in foreign exchange, they did not include the specific power to tax. And claiming that when Congress said by means of instruction, license, or otherwise means taxing is quite a stretch at best. Well, I didn't go into detail. There are some other arguments about the benefits of the tariffs and the difficulty of overturning them, but that is not a legal argument that they are valid. After all, if someone illegally takes your stuff They can't say, sorry, but it was for a good cause and keep the stuff. The government made this mess, and the government should be forced to clean it up as soon as possible. Most importantly to me, the power to collect duties is vested in Congress, not the presidency. In fact, the power to participate in foreign affairs is mostly vested in Congress through the treaty, commerce, foreign coin, piracy, and war clauses. The only foreign affairs powers vested solely in the president is the power to receive foreign ambassadors and public ministers. Whether or not you approve of President Trump's tariffs and their goals, it is a power delegated to our representatives in Congress, not the president. I know tariffs are a controversial topic, and I believe that the President Trump went too far. I find it odd to be in alignment with justices like Sotomayor and Kagan, but the truth wins out. I'm not opposed to it because they're in for it. The truth wins out. The power to tax is vested in the representatives of the people first and then of the states, and not in the President of the United States. The fact that in President Trump's mind they're working doesn't make them legal. It makes it a form of extortion, and he has used this to our benefit, but it still makes him illegal. So I'm curious where the court's going to fall down on this. Again, I try not to prognosticate about the court, but people who do seem to think that the court is leaning against Trump and for the idea that he does not have the power to tax. But we'll have to wait and see. It probably won't be until June that we actually hear an answer to this. Now, if you'd like to find out more, hey, follow me on the website, constitutionstudy.com. You can sign up for a mailing list and be notified whenever I'm publishing new articles or videos, or when I'm posting news information you might find interesting. There's a lot of stuff up there. You can find the store where you can buy maybe a book or two, or just donate to the cause. There's great ways of supporting the work that we're doing here at the Constitution Study. Another way is with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider, and they donate a portion of every dollar to organizations like the Constitution Study that are defending your rights. Join us at patriotmobile.com/constitution. Find a plan that works for you. See if you're eligible for a discount. And then when you check out, use the code Constitution to get your line activated absolutely free. It's a great way to support the work that we're doing here, along with other people that are doing the work of protecting our rights. Again, go to patriotmobile.com/constitution, find a plan and discount that works for you, and don't forget to use the code Constitution at checkout to get your line activated absolutely free. I also hope you'll share the work we're doing here, share this episode, share the article, share all the content. Maybe come back with a friend or two next time for the Constitution Study.